Hello, everyone, and welcome to today's webinar, where we'll be having a deep dive into intellectual properties practices for content creators. My name is Ngina from Africa Digital Media Institute, and I'm thrilled to be your moderator for this exciting session. And I'm excited to dive into a topic that's on the minds of many content creators today, whether you're a seasoned content creator or just starting on your creative journey. In today's digital age, content creation is a powerful tool for self-expression and communication. However, it comes with its own set of challenges. I'm sure some of us have experienced this. Particularly when it comes to protecting and navigating the intellectual property landscape. Sure that we learn from our expert today the key aspects of intellectual property and how content creators can leverage it to safeguard their creative endeavors, establish their brand identity, and thrive in this industry. I'd like to start us off with an icebreaker just to check in on you guys and find out what you are looking forward to learning today. So I'd like everyone to open a new browser on whichever device that you are using and type menti.com. So we'll share the screen here also so that you can be able to see what you're talking about. So menti.com. Yeah, so once again, I want everyone to open a new browser and type menti.com for a few minutes. It will take us a few minutes. It's also here on the screen. I'll repeat it again. You open a new browser in the device that you're using and type menti.com. That is menti.co. Yeah. So the code is also here on the screen. Yeah, so we'll start with the questions. So the first question is, describe your week in one word. So someone has said it was hectic, tiring, productive, long. Someone says it's been good, especially now that it's December. Thank you so much. So we'll go to the next question. The next question is, what type of content do you create? I'm sure most of us who have joined this webinar, we are content creators, and it's something that, we're creating. Are you a written content creator? Do you like writing, spoken words? Or is it visual art or audio? Or any other, because I know content creation is very wide. So I can see some of your responses. We have those who are interested in visual art design, in audio, and also written. Thank you so much for your responses. So we'll go to the third question. So this is the third and the last question. So what topic are you looking forward to the most in this webinar? Yeah, so we have copyright basics for content creators, protecting your brand and trademark fundamentals, or emerging issues in intellectual property for content creators. So these are just some of the topics which we will be covering in this webinar. Thank you so much for your responses. I can see most are want to learn about protecting your brand and trademark fundamentals. Yeah. So yeah, the responses are still coming in. Thank you so much. Yeah, so protecting your brand and trademark fundamentals is the topic that most guys are looking forward to learning today. Yeah. Thank you so much for participating in the icebreaker and sharing your responses. This brings us to the end of the icebreaker session. I'd like to go ahead. And now it's my absolute pleasure to introduce our esteemed speaker of today. Her name is Analo Kanga. So Analo is a Kenyan eclectic saxophonist, vocalist, performing artist, and also an ADMI faculty. She is a breath of fresh air to the African Jazz and a Cafe Ngoma Awards Instrumentalist of the Year 2022. Also, she is also a graduate from the University of Nairobi with an LLB. Has many achievements in her career as she has headlined and featured in various platforms. So today we are very fortunate to have her with us so that she can share her insights and guidance from her experience in the entertainment industry. So before we kick off, quickly, just a quick reminder to use the Q&A feature throughout the webinars to submit your questions. We'll reserve a time at the end to address as many questions as possible. Also, please ensure your microphones are muted so that you can minimize background noise. Now, without further delay, let's delve into our discussion. Analo.
Thank you, Ngina.
Thank you so much for joining us. And before you start,
yes,
I would like for you to tell us something about yourself that we wouldn't know from your bio.
Okay. Well, my bio is quite elaborate.
Yeah.
But something that you don't know about me, maybe is that I used to play sports when I was in school, and I was into basketball. So maybe that's
really?
Yeah, maybe that's something you don't know about me.
We definitely didn't know that much. But thank you so much. We've known something extra. Yeah. Thank you so much. And
thank you, Ngina. So good morning, everyone. Like Ngina has gracefully introduced me, my name is Analo. So today, like I can see most people want to hear about copyright and trademark and IP and this whole big conversation. So I'll start by giving a disclaimer that it is a very broad and in-depth topic. So today we are going to do a masterclass, and it's going to go really quickly. So whatever bypasses you, make sure if you have a pen or a paper to write it down. So let me just take a moment and share my screen so that it can be easier. Okay. So I hope everyone can see my screen.
Yes, we can see it.
Okay, so just a minute. Yes. So this is what we're going to be talking about today. Navigating the creative landscape, a deep dive into intellectual property practices for content creators. So the first thing that I'd like to say is that as we speak about content creators, I think there's a tendency to look at content creators as people who create content on social media, Instagram, Twitter, YouTube, and so on and so forth. But all creatives are content creators. So musicians are content creators, dancers are content creators, filmmakers, people who make theatrical plays, architects create content because they create designs, and so on and so forth. So just for context, as we speak about content creators, we are not limiting the conversation to people who are in social media. So I'll get straight into it. So what is intellectual property and why does it matter to me? Okay, I think it's very crucial for me to state at this particular point that the main ideas behind the protection of intellectual property is to safeguard creativity and innovation, okay? Creativity and innovation are fundamental aspects that help and assist each field of study, whether it's creative work, whether it's medicine, technology, so on and so forth. Each kind of field of study and all forms of research require creativity and innovation. So intellectual property is a word that combines two things, which is property itself. The main form of property, you know, is tangible property. So we have things like, for example, in this particular picture, you have a house, you have a car, maybe you have a chair. Those are tangible forms of property, okay? Intellect, meaning that it is created in the mind, which is a fundamental aspect of intellectual property and which makes it unique to all other forms of property laws, okay? So when you talk about, for example, getting a copyright certificate or getting a trademark for your brand, you can think about it the same way as you'd have a logbook for your car, or maybe you'll have a title deed for a piece of land, okay? So your intellectual property is your piece of land, it is your car, it is your house. So there are two aspects of intellectual property, which you can see here. There is copyright and industrial property. So copyright refers to creative works. So you have things like music, you have things like plays and written poems and literature. Then you have industrial property. So industrial property is focused on innovation. So under industrial property, we have things such as patents, which are original inventions. Very hard, by the way, to get a patent, but I'll get into that. We have things like trademark. We have things like trade secrets. Trade secrets can be anything. For example, the most famous trade secret is the Coca-Cola recipe, you know. We have things like industrial designs. So these are the unique features and aesthetic aspects of a brand or a product. The best example I can give of an industrial design is, for example, cars. So it's very easy to tell a Mercedes-Benz, maybe from an Audi, maybe from a Toyota, and that's primarily because of industrial design. We have things also like utility models. Utility models are also known as petty patents. But the difference between copyright and industrial property is that while copyright is simply a creative endeavor, with industrial property, the invention and the creative work must have an industrial or an economic value. So it must be something that contributes economically, something that can be used in manufacturing, in production, and so on and so forth. So today we'll talk about three things as swiftly as I can get through them. The first thing is copyright basics for content creators. That is my first love, copyright. Then we'll get into trademark, and trademark goes hand in hand with copyright. Remember, as I've mentioned, when it comes to copyright and industrial property, there are so many other subtopics. So we're just focusing on 2 to 3 today, okay? So copyright basics, protecting your brand and trademark. There's a difference also between a brand and a trademark, and we'll get into that. And definitely emerging issues in IP. So I think when it comes to intellectual property, one of the most emerging issues is how, for example, NFTs and blockchain, Ethereum, which protects the non-fungible tokens. How does that apply to us? It is fundamental to us as creatives. Definitely when it comes to music, the conversation of streaming and the fact that these days nobody buys CDs and DVDs. What does that mean? What does that mean when it comes to monetization and so on and so forth? So the first thing here, as you can see, is what does copyright protect and how, okay? So copyright protects several things. As you can see here, I have a few images. So the first image is music. And the biggest mistake people make is assuming that copyright only protects music, okay? But copyright protects several things. So when it comes to music and music copyright specifically, there are 2 copyrights generated for all forms of music. So you have a copyright in the musical composition or the musical arrangement. So that's the writing of the music. And then you have a copyright in the sound recording. What does that mean? The sound recording is the final version of a piece of music. So this can be the final MP3 file, the final WAV file, okay, basically the final recording. So it's very important for me to mention at this particular point, especially for the musicians, that when it comes to music copyright, when it comes to music copyright, music in copyright is divided into 2. There's a copyright in the musical composition. So that's where you'll get into the whole conversation of publishing and having a publisher to collect your publishing royalties. And there is also a copyright in the sound recording. So sound recording in the final master, in the final MP3, the final WAV file. And that's what is distributed on streaming platforms. Please remember, if you have a question or if there's something that's unclear, just write it down so that we don't forget to ask at the end. The second form of thing that copyright protects is books, written literature, poems, plays, and so on and so forth. You have theatrical plays, You have derivative works, especially when it comes to theater and so on and so forth. You have architectural designs. So something beautiful about architectural designs is, for the longest time, works by architects were not considered protected by copyright until I think the late 1990s. But architectural designs are protected by copyright. You can also copyright a blueprint for construction. Yeah, so an engineer can protect a blueprint for construction. And last, but definitely not least, you have computer software programs, okay? So here you can see you have YouTube, you have Gmail, you have Instagram, Facebook. All these computer programs are protected by copyright, and you can protect them here in Kenya today, immediately after this webinar, okay? Everyone should go and protect their copyright, and I will show you how. So it's very important also for people who are software developers and people who create computer programs and write code. Remember that you can protect your software programs. You can protect the source code, okay? You can protect the source code as a copyright. Then you also have the user interface, okay, which you generate when you're creating the software program. So the user interface can be protected as a trademark, okay, as a trademark or an industrial design. But for the source code, that is your creative work, because you're giving the code specific instructions in order to create a unique application. So some of the rights that are provided for by copyright, you have economic rights and moral rights. Okay, so this is basically how you make your money and how you prevent other people from misusing your copyright. So economic rights are very simple. It basically means the right to get money, or sort of to monetize your creative work, okay, when it comes to copyright. So economic rights can be transferred from one person to another. And this is where you get into conversations of licensing or assignment or so on and so forth. You can sign a contract and give a third party the right to make money from your creative works. So the different kinds of economic rights, you have the right of reproduction. This can also be referred to as mechanical rights, or the right to make copies. So traditionally, for example, when it comes to music, the right of reproduction meant the right to make CDs, DVDs, vinyls, and so on and so forth. But today, the right of reproduction is simply, it simply means the right to create derivative works, okay? Then you have the right of distribution. So this means, for music, you can put it on your digital streaming platforms. If it's a movie, you can give the right of distribution to Netflix, to Showmax, to put your movie out there, and so on and so forth. This is also when it comes to literature. If you're writing books or poems, you can give the right of distribution to a publisher, like maybe Macmillan, or, you know, all these famous publishing houses. Then you have the right of modification. So the right of modification means that you can make a remix of that work, okay? And this happens in music as it does in the areas of writing, and also when it comes to things like academic research. So you'll find that people who write books will have a first edition, second edition, third edition. That is your exclusive economic right. When it comes to music, you can make a remix and so on and so forth. And the right of performance. So when it comes to the right of performance, it's usually slightly misunderstood, because in the context of economic rights, the rights of performance does not just mean the right for you to perform your work to the public, but rather it also means the right for other people to listen to copies of your work. So basically it means the right for your work to be played maybe in bars, maybe to be played in matatus, and so on and so forth, for your work to be played online on YouTube, for you to do a live stream, and so on and so forth. Okay, and it's very important for, especially as creatives, for us to be very conversant with our economic rights, because you'll find that you'll get a contract and it says, so you will keep all your economic rights, and maybe the label that you're working with or the distributor is like, but we would like to keep your right of performance. And what does this look like? This looks like, for example, I'm sure all of you are familiar with Lauryn Hill, okay? So time and again, as she does her live performances, there have been numerous complaints that the songs that she performs live are not reflective of the songs that she has on digital streaming platforms. This is because she doesn't have the right of performance or the right of public performance of her work. So that means that she's not allowed to use her stems, which she created, the music she produced, her own vocals, you know, which she recorded in the studio. She doesn't have the right to use that, okay? So those are economic rights. More important than economic rights, arguably, are your moral rights. So your moral rights are basically the right to your dignity as a human person. Remember, copyright is a private right, and it's a right given to natural persons. What is a natural person? A natural person is either a human being or, yeah, it's basically a human being. So economic rights can be transferred either to a legal person. A legal person means, for example, a company, but moral rights specifically remain with a natural person. And this is a very important point, because when we speak about natural persons, we get into the lovely conversation about artificial intelligence. And can AI get a copyright? It can't, okay? As of now, as of October 2023, the High Court of America rules that, you know, AI is not a natural person and therefore is not entitled to copyright. However, I would say it's still a burgeoning conversation, and that may change. So, like my professor Sihanya told me, my professor of intellectual property, moral rights cannot be transferred. Please, please, please quote me, okay? Say that Analo said moral rights cannot be transferred unless it is written inside the contract that you are choosing to pass on your moral rights. Otherwise, it is extremely unethical for your moral rights to be transferred. So the first moral right is the right to integrity of the work. So people need to respect the fact that you are the creator of the work. Right to accreditation. So that's your right for someone to say, so-and-so is maybe the producer of this work, so-and-so is the author, so-and-so is the writer. Or the right to anonymity. And what does that mean? As the creator of a copyrightable work, you have your moral right to say, I do not want to be associated with this work ever until the day I die. So it is also your right to say, I never want to be credited for this work. I never want anyone to say I was part of this project. That is your moral right. And last but not least is the right to object to distortion, okay? So this also means that people cannot use your work in a way that you do not deem fit. What does this mean? For example, as the creator of a copyrightable work, you can say, I don't want my music to be used, for example, in horror films, okay? I wouldn't want my literature to be modified into maybe a pornographic story or so on and so forth. Basically, you have the right to choose how your work is used. Those are your moral rights. Remember, I have said today, moral rights are not transferable. Economic rights, however, are transferred left, right, and center. Okay, unless, of course, it's written in your contract, which you didn't read, because sometimes we don't read our contracts, but yes. So other characteristics of copyright, you have here originality, tangibility, automatic or automation, and definitely the duration. These are very important aspects that you need to talk about. So basically, to establish a copyright, the copyrightable material must be original. What does that mean? It means that it must originate from the creator. So you cannot copy somebody's work and file for a copyright, okay? It must originate from you as a creator. It must come from your intellect. It has to be from you. It must originate from you. Tangibility. What does this mean? Remember, we're talking about property, and property is something that is tangible and that can be owned. Now, tangible doesn't just mean that it's a physical copy. It can also be a digital copy. So a tangible format just means a fixed format. And this is very important because copyright does not protect ideas. It only protects the expression of ideas, okay? So you can have the biggest or the most grand idea in your head. You can have the most amazing idea of a source code that you can write to create the most unique application ever. You can have the best idea of a film or a script in your mind, but for so long as you have not expressed that idea in a tangible or a fixed format, then copyright cannot protect it. This is very important because sometimes people claim that their ideas were stolen, especially in the creative space. You know, that's a hot topic. But If you haven't made a recording of that song, if you haven't written down the sheet music, if you haven't written down the poem, if you have not expressed it or removed it from your mind into a tangible format, copyright cannot protect you. And the beauty about even tangibility is that even if you want to look at it maybe like from a spiritual perspective, there's the whole concept of ideas are in the universe gives ideas, or if you're religious, God gives ideas, okay? And if you do not express an idea, he will give that download to the next person, and then you'll see your idea in someone else. If you don't do it, someone else will. So copyright only protects tangible forms of ideas. Copyright is also automatic. What does that mean? It means that in as much as today we'll talk about how you can protect and register your copyright, copyright is automatic in the sense that once you have created a piece of work, you already own the copyright to that work, okay? So you do not have to register copyright in maybe the Kenya Copyright Board, or you don't have to sign up with a publisher in order to prove your copyright. Copyright is automatic. However, we register so that we can ensure another layer of protection, okay? It's very important. So I think about copyright, think about a copyright certificate, think about it as a white picket fence around your house. So your house is the copyrightable work, and your copyright certificate is a white picket fence. So it's another layer of protection, but definitely a white picket fence. If somebody wants to jump over the fence and steal from you, they can still do that. And the duration of copyright. A very important other matter is that copyright does expire. So copyright does not exist in perpetuity or forever. Copyright expires. So in Kenya, for example, the duration of copyright is the life of the author or the life of the creator plus an additional 50 years, okay? So if you create a work today and then you live for another 50 years, so today is 2023, in 50 years is 2073. So your copyright will live up to 2073 plus an additional 50 years. Remember, duration of copyright is also different according to different jurisdictions. So while in Kenya, it is the life of the author plus an additional 50 years, you'll find, for example, in the United States, the duration of copyright is the life of the author plus an additional 70 years, okay? So those are some characteristics of copyright. Then you enter into split sheets. So if you're a musician from today and you're on this webinar, I expect you to always use a split sheet in all your arrangements. So basically a split sheet is a written contract that provides percentages of contributions of different performers in a musical piece. What does that mean? So if we have 5 people in the studio and we are creating a song, you're the producer, the artists, the musicians, BGVs, and maybe the guitarist, we're going to sign a contract that says the producer contributed 20% to this song, the guitarist 10%, the singer 2%, the engineer 1%, and so on and so forth. Split sheets agreements are crucial because they enable people who collaborate on a piece of work to own a percentage of the copyright, okay? Then you also have performance agreements. So performance agreements are not only for music, they're also for theater, they're also for written works and so on and so forth. They're also for dancers. And basically it means that once you perform a piece of that work, you are entitled to a percentage of royalties from that work. So this can mean, for example, the simplest explanation I can give is that if you write a song and you invite someone else to just do a verse, they are entitled to a performance agreement. So split sheets and performance agreements are very crucial when it comes to copyright. And last but not least, the National Rights Registry. What is the National Rights Registry? The National Rights Registry, or the NRR, is the website that allows you to register your copyright here in Kenya. So if you want to register your song, you want to register your source code, you want to register your poem or a written book and so on and so forth, you go to the National Rights Registry, and that's how you register your copyright. So yeah, remember today that registering your copyright in Kenya, I think it's also just 100 shillings, but I believe for a source code or a software, it's 500 Kenya shillings, but basically that's where you get your copyright certificate. It is very crucial. So you just log onto NRR and follow the instructions there. So contracts that involve copyright, okay? So as creatives who create work and we are in the workspace, there are different contracts which we are likely to come across. So some of the contracts that you'll get, or most of the contracts that you'll get, will either be commissioned work or work for hire, Okay, so the example here I've given is a musical example, and commissioned work versus work for hire is crucial because it stipulates how economic rights will be pursued after the completion of the work. So in the context of music production, both commissioned work and work for hire arrangements involve hiring a music producer to create music, but they differ significantly in terms of copyright ownership and control over the resulting work, okay? So what does ownership in commissioned work look like? So when a music producer is commissioned to create a piece of work, this is not only a music producer, but any creative who is asked by a company or a commissioner to create a piece of work. The default assumption is that the producer retains the copyright to the music, okay? In this scenario, the music producer is considered the author of the work and they own the copyright. How is this different from a work for hire agreement? So in a work for hire arrangement, the copyright to the music is owned by the person or the entity that hires the music producer. The music producer is not considered the author. Instead, they are creating the music as an employee or on behalf of the hiring party. Okay, so let me simplify all this jargon of commissioned work versus work for hire. So basically, when it comes to work for hire, the simplest example I can give of a work for hire arrangement for a creative or for a content creator is an employment contract, okay? So an employment contract basically has an employer-employee relationship. And 9 times out of 10 or 9.5 times out of 10, as a creative who has an employment contract, all the work you make during the duration of your employment is the copyright of your employer. Okay, so if you ever exchange money or somebody gives you money for your creative works, I assure you, you have given up your economic rights, unless you have specific clauses in your contract that stipulate otherwise. However, 90% of the time in a work for hire agreement, once you have an exchange of money, okay, from maybe your employer to you, then you have given up your economic rights. But remember, like I've already said, moral rights are not transferable. So in as much as the copyright ownership will remain with the employer, you are still entitled to your moral rights. Now, that's for work for hire. When it comes to commissioned work, now this is now project-oriented, which is now the sort of freelance kind of work. You know, you come in with your equipment, you just do a project and you leave. So the simplest explanation I can give is he who commissions a piece of work owns that work. He who commissions a piece of work owns that work. The only difference between commissioned work and work for hire is that when you're in an employment contract, you don't have complete creative control under of the work that you create, okay? So you must meet the KPIs or you must meet sort of certain things that you have to meet for your employer. But when it comes to a commissioned work, you're ideally being hired to put a lot of creative work into the project. So you may have more creative control over the work. However, the ownership still lies with the person who gives you money, okay? And that's the difference between authorship versus ownership. So authorship is always the person who creates the piece of work, but ownership, which means the person who has the rights to control the economic rights of the copyrightable work, is absolutely transferable. Okay. So let me go to the next slide. So you have exceptions to copyright. So copyright is not a do-all, end-all, okay? There are several exceptions to copyright or things that can happen that can show that maybe copyright is not enforceable or you don't have to seek permission from the author of a copyrightable work. So the first exception to copyright is the fair use doctrine or the doctrine of fair use. So this basically means that there are instances where you can use somebody's copyrightable work without infringing on their personal, economic, or moral rights. So the fair use doctrine applies in a couple of areas. For example, when you're using a copyrightable material for educational purposes, this means that if you're teaching in a music school, you can play songs that are copyrightable or songs that are on DSPs because you're doing it for educational purposes. This is also when it comes to literature. So you'll see even in schools, we use set books and so on and so forth. And we are allowed to use and to go through that copyrightable material without infringing on people's copyright. You also have parody. So you'll see on YouTube, there are people who make videos that are parodies to other people's work or songs. That's an exception to copyright. You have non-commercial use. So a key aspect of not infringing on someone's copyright is not making money from somebody's copyright. So if you're using somebody's work in a way that's non-commercial, maybe you're using it under your non-profit organization or so on and so forth, that's allowed. The news and the media are allowed to use copyrightable material when they're using it for reporting to the world, and definitely judicial proceedings. So basically that means in a court of law, if the court asks for you to bring your copyrightable material, then that is deemed fair use. The second exception to copyright is public domain. What does that mean? So like I mentioned already, copyright expires. Copyright does not exist until the end of time. So once the copyright expires in whatever form of copyright it is, the work enters the public domain. That means everyone in the public has access to use, reuse, modify, or copy that, or make copies of that particular work, okay? So maybe an example of that I can give is like you have hymns, okay? So very old hymns that we sing in church, a lot of those songs are in the public domain, okay? You can see music that's from long ago. You have maybe very old literature, very famous old literature. Those are sort of exceptions to copyright. You'll not find software that's in the public domain, simply because when it comes to tech and IT, these are very new and modern concepts, and they're being created daily. So another exception to copyright is unconscious copying. And please remember, as I speak about all these particular exceptions to copyright, they are very hard to prove. They are very hard to prove. So I'm not giving you ammunition, I'm just giving you understanding. So unconscious copying basically means it also means innocent copying. So you're using or creating somebody's work without the knowledge that that work exists already in the world. Very hard to prove. You have the doctrine of substantiality. What does that mean? It basically means that, did you use enough of the creative work or of somebody's copyrightable work in order to cause infringement? A simple example I can give of that is how you'll see YouTubers, when they create videos on YouTube, they can play just small snippets of a song before they get a copyright infringement. So they can play like 2 seconds or 3 seconds. And there you can argue the doctrine of substantiality, that if you play a song for 3 seconds, you have not infringed on somebody's copyright, you're not likely to make millions from that. Then you have the Creative Commons. So the Creative Commons license is the biggest nonprofit organization in the world that protects copyright and allows people who create copyrightable material to put their work in the public domain and allow others to use it. So every time you upload, for example, your content on YouTube, they'll ask you, would you like a standard YouTube license or a Creative Commons license? So the Creative Commons license allows other creators to use and misuse your copyright work legally, okay? So Creative Commons is actually an organization that provides those licenses for other people to use your creative work. So trademark. So trademarks are used for commerce, okay? So as I speak about trademark, please remember that trademarks are used for commerce. Trademarks are used for business. So in this particular slide, you can see there are several trademarks here. You have Google, you have Coca-Cola, you have Apple, Samsung, Starbucks, like very famous trademarks, okay? So trademarks is basically a mark that represents a trade. So a trade is either a good or a service, okay? So a trademark is basically a sign that is used to distinguish the goods or services offered by one undertaking from those offered by another, okay? So what does that mean? For example, when you go to the supermarket, you find, and you go to the bread aisle, okay? There are so many companies that make bread and everything. But what makes you pick, for example, Festive bread instead of Broadway's? It's because of the trademark. It's because of the design. When you look at Festive bread and you see the way they advertise for you on the TV, you're like, yes, this bread makes me festive, okay? But all this bread is made exactly the same. It's the same thing when it comes to things like, for example, when it comes to things like soda, Coca-Cola or Pepsi or everything, All these kind of drinks taste similar to each other, but it's because of the trademark that the user is going to be, or the consumer is going to have an idea in their head that I associate this typical brand with quality, I associate this typical trademark with goodwill, and therefore it will make you choose one product instead of the other. So as you register your trademark, remember that you have to use trademark, and trademark is for business. So as you register a copyright, you don't have to monetize your copyright. But when it comes to trademark, you must be in business, okay? So two aspects of trademark. When you want to establish a trademark, it must be distinctive and it should not be deceptive. What does that mean? So when it comes to distinction, it means that your trademark must be unique in terms of design, in terms of colors, in terms of font, and so on and so forth. So it must stand out from another sort of brand. That's why you'll see, especially brands that work in the same industry, for example, when it comes to Safaricom and Airtel, they have very distinct trademarks that are separate from each other so that you do not confuse the two, okay? And it should not be deceptive. So what does deceptive mean? It means that, for example, if you want to trademark or you want to sell an alcoholic drink, you cannot label it as the most energizing energy drink under the sun, okay? That is deception, and it is unethical, and it violates consumer protection principles. So to establish a trademark, it must be distinctive and it should not be deceptive, okay? So a trademark basically consists of words, designs, letters, numerals, or packaging, slogans, devices, etc. And then you can see here on the slide that there is that small R at the top that represents trademark. So trademark versus branding. So trademark is a legal process that protects specific elements of a brand, such as the brand name or logo. Branding, on the other hand, is a broader and more strategic effort to build and manage the overall identity and perception of the brand, okay? So this is the messaging, the lifestyle, the tagline, value addition, goodwill, consumer protection, etc. So your trademark will represent either a good or a service. So a good or a service means, like, for goods, you can be selling clothes, you can be selling whatever. And when it comes to trademarking, there's a difference between a trademark and industrial design. So sometimes, especially in the world of fashion, people want to copyright or protect the shape of the fashion that they create, or the brands that they're working with. But remember, when it comes to fashion, fashion is extremely fast. And when it comes to the world of fashion, everyone is infringing on everybody's design every single day. So it can be very hard for you to make a trademark or secure a copyright for a design. However, what you actually want to build is your trademark, and your trademark is supported by your branding. So your branding is sort of the lifestyle, the culture, it's the ideologies that you sell behind your product or your service, okay? So branding really goes hand in hand with a trademark. A strong brand will easily formulate into a trademark. What does that mean? You'll find, like, for musicians, they have really strong brands. So maybe somebody like J. Cole, yeah, or Beyonce or Rihanna. These are people who have very strong personal brands. There are ideals that they represent, you know, there's lifestyles that they sell, and they'll transform that brand into a trademark, okay? But remember that trademarks are used for business. Trademarks are used for commerce. So you can have a copyright certificate and put it under your bed and leave it there. But when it comes to trademark, you must be in business. So while trademarking provides legal protection for specific brand elements, branding is the holistic effort to create a unique and compelling identity. So when you're thinking about branding, especially as a creative, you really want to think about, one, what is your value system as a person, okay? Especially in the creative world, you know, people buy people. So people do not buy logos, they don't buy designs, they don't buy brands, they buy people. So what are you selling to the world? Are you selling wealth? Are you selling lifestyle? Are you selling culture? Are you selling religion? You know, what ideals are you selling? So your brand is very crucial as a content creator. And please allow yourself to rebrand as well. So how do you register for a trademark in Kenya? You go to the Kenya Industrial Property Institute, okay? You go to the Kenya Industrial Property Institute. Remember I said for copyright, you go to the National Rights Registry. For trademark, you go to the Kenya Industrial Property Institute, okay? Then you can see the steps that you're supposed to conduct there. So there's a preliminary search to make sure that there's no coexisting trademark. You make a formal application. then there's a formal and substantive examination done by the Registrar of Trademarks. And basically what they establish is your trademark distinctive and not deceptive? Then it's advertised in the KIPI journal for 60 days in case somebody wants to say no to your trademark, and then registration is complete. So for trademark, remember you register your trademark at the Kenya Industrial Property Institute. Trademark is also, trademark also expires. So there are certain instances where your trademark can be removed from the Registrar of Trademarks. One, failure to renew your trademark. So trademark exists for 10 years. As we said, copyright is the lifetime of the author plus an additional 50 years. Trademark exists for 10 years. Then number two, you can request to have it removed from the Registrar of Trademarks. And number three, very important, this is the point I was getting to, removal for failure to use trademark. So if you cannot prove that in the past 5 to 10 years, you have not used your trademark in business, i.e. you have not used it to represent and sell either a good or a service, then it will be expunged from the Registrar of Trademarks. The idea being you might be preventing somebody else from using that particular trademark in business, okay? I know I'm rapping, but I hope I am making sense. Then you have cancellation on nullity. This basically means maybe when they did the examination, your trademark did not meet the requirements of distinctiveness and non-deception. Then losing its distinctiveness. So what does that mean? For example, I know we all know what elevators are, and we look at elevators as those moving steps in the mall, okay? But did you know that elevator was actually, or is actually a trademark, okay? So it doesn't directly refer to the moving steps, but the idea is everyone started calling all forms of elevators elevators. So different manufacturers would create elevators and everyone would just call them elevators. So instead of calling them, for example, a Mercedes or an Audi, everyone is just calling them elevators. So at that point, it loses its distinctiveness. It is not unique. This can also happen if we all start, for example, calling all the sodas Coca-Cola. So Coca-Cola as a trademark would lose its distinctiveness. So trademarks and limited liability companies. So like I said, trademarks are for commerce and they're for establishing businesses, okay? So the ideal business structure that you would want to register as a content creator, as a creative, when you're going into entrepreneurship in business, is a limited liability company. Kindly consult also with a company lawyer or somebody who does company law as you establish a business. There are different forms of businesses that you can establish in Kenya. You have limited liabilities companies, you have partnerships, you have sole proprietorships. That's probably ideal if you don't have money and you're not paying taxes. You have companies limited by guarantee and limited liability partnerships, public limited companies, and so on and so forth. But LLCs are ideal for carrying out your business, especially as a content creator. It provides room for you to scale. It also separates you as a person from you as a business, okay? So all the debts of the business will not come directly to you as a person. So your LLC can be the legal entity that owns and operates your content creation business. So definitely there's a procedure for you to follow. You can register a company from the heart of your home, but kindly consult either the company lawyer, a certified public accountant, or a certified public secretary when you register your business so that you can follow the procedures directly, okay? So the trademarks associated with your brand can be registered in the name of the LLC. Yeah, so once you register your trademark, you can use that brand name or logo to be the same name of your limited liability company. So combining an LLC with trademarks provides a dual layer of protection. Remember, as a creative, we can protect many things at the same time. So you can have your copyright for your work, then you have your trademark for your brand, and then now you have your LLC. This is so crucial. And protecting yourself legally is the surest way for you to establish or to start building your creative pursuits and for protecting your money and protecting all the work that you do, okay? So the LLC protects your personal assets from business liabilities. That's very important. You want to separate your personal debt from the debt of your company. So these are some key terms in contracts. I don't think I'll be able to get through all of them, but I'll just wrap through them very quickly. As a creative, these are some words that you need to remember. So if you have your phone, kindly take a screenshot of this particular slide. in case there's a word that I don't get through. So you have perpetuity. This basically means that somebody is going to have ownership of your material until Jesus comes to collect the Christians. I hope I'm very clear. Perpetuity means until the end of time. Retention period, and this is especially when it comes to music and contracts for recording, distribution, publishing, and so on and so forth. So basically, you can have a contract that is 5 years with a retention period of 10 years. That means that whilst your contract will only be for 5 years, and after 5 years, you can enter into another contract, the work that you create, whether it's music or your masters, will retain with the company for an additional 10 years. This is in order for them to get royalties over a longer period of time. Cross-collateralization, this basically means that especially when it comes to creating either music or literature, books, etc., you can use the income from one particular project to fund the next project. But that's just a simple way of putting it. Force majeure just simply means acts of God. So these are natural acts that can prevent you from enforcing a contract. You have obligations of each party. So remember also as creatives, not even forgetting all these fancy words here, all contracts are negotiable. And this is why you always need a lawyer when you're doing your business transactions. It doesn't matter where you are in your career. So definitely when you're starting out, you don't have maybe a lot of power when it comes to negotiation, but all contracts are negotiable. Please quote me. Please remember, Analo has said all contracts are negotiable. So you can just decide what you want to do, what you don't want to do, what works for you, and so on and so forth. Always have a clause that stipulates how the payment plan is going to be done. Confidentiality. A lot of contracts are protected by confidentiality agreements, meaning don't share with your friends and your mom and your brothers and your girlfriends. Termination clause, this is very important. How are you as the creative allowed to terminate the contract without being in breach of the contract? Duration of the contract, very important. Duration of the contract goes hand in hand with retention period. And a lot of people overlook the retention period and say, I entered the contract for 5 years, but technically you entered it for 15 years. And it gets worse. You'll see even in bigger industries, retention periods go for 30, 35 years. It's not a joke. Obviously, you need to know the jurisdiction or the laws applying to the contract. So is it the laws of Kenya? Is it the common law of the UK? Is it American laws? And finally, ADR, alternative dispute resolution. So when it comes to stealing your copyright or your trademark, you do not want to go to court. You actually do not want to go to court. So you'll have other forms of dispute resolution, like negotiation, sorry, not negotiation, but rather mediation, arbitration, and so on and so forth. Always have an ADR clause in your contract. You can augment, you can negotiate, you can talk to the person who you're creating a contract with and say, hey, let's add another clause that stipulates mediation in the case of disagreement. Licensing versus assignment. So basically this means assignment doesn't mean the same thing it means in the real world as it does when it comes to the world of copyright and IP. So licensing means giving somebody a permit, a temporary permit for them to use your creative work. So when you license something, it will eventually revert back to you. Assignment means when you give ownership to someone of your creative works for good. So assignment is basically selling away your copyright. So anytime you see the word assignment in a contract, it means basically selling away your soul, okay? So that's the difference between licensing and assignment. Common types of licenses are mechanical licenses, basically the right to reproduce and distribute your work. Performance licenses to put your work in public spaces, and synchronization licenses. This is very common, especially in the music business. This is putting your music or your work into films, Netflix, Showmax, and so on and so forth, okay? So the second last thing I'll talk about is non-fungible tokens. So these are assets, okay, that verify ownership. So non-fungible tokens is a very other broad conversation. It means things to do with blockchain, Ethereum, NFTs, there are also fungible tokens, and so on and so forth. So basically the idea is that NFTs are creative works that are in digital format, and they can be protected using blockchain technology and specifically Ethereum, okay? So NFTs and Ethereum. That is a conversation that we must have as creatives. And how do we get into it? How do we monetize our work? Remember also, when it comes to NFTs, there's still a difference between authorship and ownership. So people are putting digital works that belong to other people online and purporting to be selling their copyright authorship when they actually do not have the ownership to it in the first place. So what are some key aspects of NFTs? They tokenize digital assets. Basically, they create vouchers or tokens of digital artworks online. And NFTs are, you can think about NFTs like a gallery, okay? So a gallery of music, a gallery of paintings, and so on and so forth. There's a difference between ownership, token ownership versus copyright ownership. So owning an NFT does not mean that you are the owner of that copyright. That is something you need to remember today, okay? If you own an NFT, it doesn't mean that you are the owner of that copyrightable material, okay? Then NFTs also led to the emergence of smart contracts. So smart contracts are self-executing contracts with terms directly written into code, okay? So basically, I would add, maybe when we have more time on another day, we can definitely get more into NFTs and Ethereum, non-fungible tokens. So non-fungible basically means non-exchangeable. It means unique. It means one of one. And that's why it's used when you're talking about copyright, because copyrightable material are unique materials. A trademark is very unique. It's one of one, and it is distinguishable from other forms. So when somebody infringes on your IP, what are sort of the things you can do, or what are sort of the reliefs you can look for? Please remember, as I've already mentioned, you do not want to go to court. You actually do not want to go to court. Going to court takes several years and hundreds of thousands of Kenya shillings. But I mean, if you want to go to court, that's still great for entertainment lawyers, will be happy. So there are certain things you can do when your copyright is infringed. You can ask for an injunction. That's a very big word to say. Stop misusing my copyrightable materials. You can ask for damages. That means, how much money did you make from copying or reproducing my work? Give me all that money back. You can have an account of profits. So basically, they show you their balance sheet of the money they made from misusing your copyright. You can have seizure of the infringing copies, and that's something that Kekobo does a lot. Then you can have also delivery app. So you can ask the person to bring the copies of the work that they did back to you, destroying the pirated material, and definitely ADR, okay? So how is copyright infringement protected in the digital age? You have digital rights management systems, those are DRMs, and TPMs, technological protection management systems, okay? So that's also something you can look into, DRMs and TPMs. So this, last but not least, because I can see our time is up. I'm sorry, guys, I've done my best. These are some of the bodies that you need to look into when it comes to copyright and trademarking. So you have Kekobo. Kekobo is the statutory board that overlooks all the other copyright boards in the country. That's the Kenya Copyright Board. The Kenya Copyright Board is actually the creator, or rather the host, of the NRR, which is the National Rights Registry. So Kekobo belongs to the government, okay? Just think about it like that. You can think about it like Kenyatta Hospital or University of Nairobi. That's Kekobo. Then you have the notorious collection management organizations. So you have MCSK, Camp Prisk, so Music Copyright Society of Kenya, Kenya Association of Music Producers, Performers' Rights Society of Kenya. Those are the 3 CMOs in Kenya. So these are the people who you sign up to for them to collect your royalties of your copyrightable material. Then we have the Recording Industry of Kenya, especially for musicians. You need to look into the Recording Industry of Kenya. It was just established. It was launched, I think, late October. It has a very impressive board consisting of people like John Katana, you have Bien is on the board, you have people like Musioka, and so on and so forth. So this is ideally, if you're into the recording industry, especially producers and engineers, look into Rike. And finally, KIPI, Kenya Industrial Property Institute. That's where you register your trademark or your industrial design or your patent if you're innovative, okay? So this is my last slide. As I finish, these are some things that you need to think about. So An entertainment lawyer is imperative to all your business transactions as a creative. Get somebody who is passionate about it. As you have seen today, I'm sure everyone's brain is on overdrive. There's so many things to think about, okay? Entertainment law is extremely niche, and always look for an expert. So there are entertainment lawyers, but not many. So if your friend who does tax and I don't know, company law and family law is telling you they're into entertainment, think twice, okay? Remember that creating art is a calling, and it's also a very spiritual endeavor. So as creative, it's very important for us to always do our best when we're creating work and take it very seriously. Policy development is still required, because we cannot achieve any of the things we want to achieve in this industry without access to credit and finances from both the public and private sector. So yeah, that's all I have for today. If you have any questions, you can ask. So I'll stop sharing my screen, and then maybe Ngina, you can help me with the Q&A.
Thank you so much, Analo, for the incredible presentations. So your insights have been truly illuminating and informative, and I'm sure our audience have learned a lot and are eager to apply these practices in their creative endeavors. So I personally have learned a lot. I didn't know that elevators are trademarks for once. You know, we usually don't like taking the stairs. We are there, you know. Yeah, and also the fact that, you know, the difference between branding and trademarks. I always thought they were, you know, they go hand in hand, but you can be a brand, but, you know, trademark is the business side of it. But that's something that I didn't know and that I've learned. Yeah. So we'll get right into the Q&A session. So we have someone, Paul Mwangi, who will say that he has gained a lot from this session, and that's currently he's a graphic designer for his company who creates visual for the social media team. So he recently noticed a competitor using similar graphics, and once they even used one of his, but without their logo. So how is he supposed to address this, and what advice do you have for him moving forward?
So maybe what he can do first, I know I went really quickly through how to address when somebody infringes your IP, but basically he should start by sending a cease and desist letter to the company. So basically asking them to stop using his copyrightable material. If there are people who are very serious about their business and wouldn't like to get into legal quarrels, then they should take it down. If they refuse to take it down, then maybe now you can seek the assistance of a lawyer or an advocate for you now to go into court proceedings, okay? And even before that, try and do some mediation. Maybe you can come to an agreement. Maybe they can cut you a check. You know, there are so many options.
Yeah. Okay. So next question, can you trademark someone else's name?
Absolutely not. No, no, that's that, no.
Yeah. Another question Anne Waithera has asked, is it that this principle can apply to other contracts other than the entertainment industry?
Absolutely, absolutely. It's just that there are definitely different industries have different ideals and different ways of working. But yes, these are things to think about. Like you said, there's a way you can look at the reward retention period. You might not understand. Assignment, like I said, it means selling your soul, but that's not its meaning in English. So yeah, cross-collateralization, just you need to be aware of what the terms mean.
Okay. So Kenya has asked, can one copyright content creation?
Yeah, absolutely. So it just depends. What is it? Is it a song? Is it a video? Is it a book? Is it a poem? You can do that, but you need to be sure about what it is or what form of copyright it is that you're protecting.
Oh, okay. So Abigail has asked, am I infringing copyright by including somebody's music in my content as it is on DSPS, e.g. on YouTube or on a podcast? So also the same question, but with the music recorded during a live session.
Live session like in a concert? Okay,
Yeah,
so
yeah,
that's
or
different. So
legal,
if you
yeah.
use somebody's music that's on DSPs, you are infringing on their copyright unless you ask for permission. And I think that's like the annoying aspect about copyright. You can use somebody's work if you ask for permission. However, it can be more complicated if they're using a record label or a distributor, because if you put that work online, it will get a copyright strike. Then your work will be taken down. On YouTube, for example, if you get 3 copyright strikes, your YouTube account is destroyed. So yes, you are infringing on it, but you can get permission. So they'll ideally send a copyright claim to the owner of the copyright. Then they can decide, do I want to monetize this video, or do I want them to stop using my copyrighted work?
Okay. It's the same with when one is recording a live session.
So when you it's very nuanced, because when you record in a concert, that recording is your personal copyright, the recording of the work that you do. However, you don't have the right of public performance, so you cannot monetize that work. And I guess like the most common place where people monetize live streams is also on YouTube. Yeah, so like if you're not monetizing it, then you're not infringing copyright. But if you are, then yeah, you can get a copyright strike depending on how strict their DRMs are. So their digital rights management systems, that's basically a software that can detect copyrightable material online.
Oh, I hope Abigail Analo has answered your question. So we have someone from Ghana, Gabriel Kwai. Yeah. So he's asking, what about people from Ghana? Is your presentation only for Kenyans, or can he apply it?
So you can apply it for so long as it does not for so long as it's not different from your personal laws. Okay, so as in for copyright, it's generally international. So there's like the Berne Convention, which like all self-respecting countries in the world are a member of, and basically we all have similar laws, but there are small differences. Like I said, in Kenya, copyright is the life of the author plus 50 years, but in America, it's the life of the author plus 70 years. So you just need to find those differences. When it comes to things like commissioned work and work for hire, Section 30 of the Copyright Act of Kenya stipulates that the contract must state that it's a work for hire or commissioned work, or the copyright remains with the author or the msanii. So you still have to get into understanding your personal laws, but by and large, they are very similar.
Okay. We have 2 more questions.
Okay.
So what are the top 3 trends to watch out for in Kenya in intellectual property?
Wow, that's a very broad question, but that's really good. So I'd say first of all, streaming, both of music and film. There are distributors that are coming into the country that are really interested in working in Kenya. So you have things like 1RPM. They're very looking forward to distributing a lot of music in the country. So how can we work with them? I would also say when it comes to policy formation, you have people like Kekobo, you have Pangasana, you have Recording Industry of Kenya. They are really looking into policy formation. And the only way you can have policy change is through taking all these ideas and passing them as bills in parliament. So some of these bodies actually are looking into financial assistance to look into change in that aspect. But also, I mean, when it comes to IP in Kenya, the world is a global village. So also, I guess as creators, we can also change our target audience. You don't necessarily have to create content for Kenyans and what that would look like. Yeah, but I'd say policy formation, financing, and distribution of work online.
Okay. So the last question by Joyce Alimu. What if I signed up perpetuity, but I changed my mind years later? Can I hit them with the all contracts are negotiable?
So I'd say if you do that, get a really good experienced lawyer, because law is so beautiful. It's not really about what is written, but the interpretation and how you can argue your point. So if you get in the deep end of the deepest end, get a good lawyer and try. But ideally, you just want to prevent that by by sitting down with a lawyer in the first place, because it can be hard for you, Gina, for example, if you're entering into a contract, for you to think about all the legal aspects of your contract. Yeah, you're looking for work, you need to get paid today, you need to pay for Wi-Fi today. So just try and start with a lawyer so that you don't get there at the end.
Yeah.
So contracts are negotiable before they are signed. Sorry. Yeah.
Yeah, Joyce, I hope you understood what Analo has said and she has answered your question. So that is the last question today. Thank you so much, Analo, for taking the time and answering the questions. It was very insightful. Yeah. Yeah, so this brings us to the end of Q&A session. Thank you so much, everyone, for keeping this session lively and also engaging. Yeah. I want to take this moment to bridge the gap between now inspiration and action. So for those who are ready to transform your passion into a successful career, so we at ADMI, we offer a thriving community, practical courses in creative media and technology, and tools to unlock your creative potential. So we'd like to, talk to you and offer guidance on the courses that are best fit for your interests. We have our contacts on the screen. You can also visit our website and also engage with us so that you can be able to assist in one way or the other. So thank you so much, everyone, for taking the time to join us. And we hope we see you on the next one. Yeah. Thank you so much.
Also, I guess I can also share my slides in case anyone wants them. So I can send them to you, or?
Yes.
Okay, no problem.
Okay. We'll just share it to them later on.
Yeah.
Thank you so much, everyone.
Bye-bye.